Hi, everyone, and welcome to another weekly news roundup with LGB Alliance USA. And we're going to talk about a number of things today, but we're going to begin by talking about Title IX because the recent Title IX implementation has been finally formally released. Previously, they had released proposed revisions or proposed implementation, and now they have finally released their actual formal implementation. And here to discuss this implementation is going to be an expert on this, Candice Jackson. We've had her on our podcast before, back when the proposed revisions to the implementation were out there. So we're pleased to have Candice here explain to us what exactly is going on. What is the bottom line with this implementation from the Biden administration? And with that, Candice, we'll hand it to you.
Well, sure. I think a lot of us that have been following this are aware that the biggest change is that now the education department is explicitly defining sex discrimination to include discrimination based on gender identity. Sexual orientation is also included, and I'd actually like to talk about that as a separate issue. I don't think there's necessarily an automatic, hey, that's great, or hey, that's totally awful. I think there's some mixed things in including sexual orientation. But the gender identity piece, to now have Title IX, the official interpretation, say that schools and colleges and universities are barred from treating anybody inconsistently with their gender identity. That's the new Title IX standard. New being a relative term, right? Because the Biden administration took this position from practically day one. And so the Office for Civil Rights in the Education Department has actually been enforcing this direction, even kind of cheating well before, for years now, well before they actually took the time to go through the administrative process of putting out their formal rule, taking public comment, responding to it, and now releasing their final rule. They've been enforcing it this way for a while, and so we've been seeing a lot of school districts and colleges and universities take this approach toward gender identity discrimination for quite a while now. The difference now is going to be that for the schools and institutions of higher ed that have held firm to single sex spaces and not enforcing pronoun rules and wanting to keep Title IX sex based, for those institutions, this rule now endangers them in terms of being able to continue any of those policies. I think it's a good sign that you're seeing so many states. I think it's up to 26 states now have formally joined or filed lawsuits in court to challenge this rule. And so I think you're going to see a lot of pushback by institutions that just say, this is too much. And I realize that my federal funding is on the line here, but so be it.
Oh yeah, I was going to ask what's going to be the consequences to these schools that had previously held out and.
Yep. That's it. It is interesting. And I think for the first time in federal civil rights education history, I think we're going to have a true showdown, because the only punishment, the only stick that the education department has is, at the end of the day, terminating federal funding for an institution that refuses to comply with a federal civil rights mandate like Title IX. In the history of the education department, they've never actually terminated anybody's funding. It's come close a handful of times, but there's a real process to it, because it is kind of a big deal. You got to go through the Department of Justice, and they have to take it to, through an administrative law judge process. And so almost always the school or college ends up backing down and reaching some kind of voluntary resolution to the whole thing. And so termination of all federal funding to that school just has never actually happened. I think this is going to be the line in the sand. I think we're gonna see institutions with states backing them up, being willing to say, if it comes to that, no, we're just not going to comply.
I'm curious, do you have any idea how much money some of these generally schools get from the feds?
Yeah. At the K through 12 level, federal funding usually represents 8, 9, 10% of the budget. It depends on how you look at that, right? Is that significant? Absolutely. Is it everything? No. Especially, again, if you've got states backing up their own K through 12 systems and maybe starting to figure out ways of replacing that or helping districts, turn that down or be willing to turn that down, knowing that there's, other sources maybe from within the state to try to make up for it. At the higher ed level, it's a little different. There are many sources of federal funding. The most impactful one might be the fact that if a college or university lets students in and the students are receiving federal loans, that is the hook for the university having to comply with Title IX. That's a big deal. That is a big deal. If a college is going to say,
they would cut funding for the students trying to go in.
They wouldn't cut off the student's federal loan, but the institution wouldn't be able to enroll a student using that federal loan. So that could potentially be a pretty big issue.
Yeah, I can see that.
So I just wanted to clarify too the scope of this implementation and the scope of gender identity. This does, from what I understand, trying to read through the implementation, it does cover things like bathrooms and locker rooms.
Yeah.
There was an exception given there were 2 exceptions I saw they were trying to carve. One was for housing and one was for sports. And I'm wondering if you could elaborate on what that means.
Sure. Okay, so the Title IX statute itself, the basic statute just, says no person, on the basis of sex shall be subjected to discrimination. Then there are a couple other sections in the statute that Congress passed that at the time in the early 70s represented, I guess, some of the things that were so common to sex separate in schools that Congress went ahead and listed them out in the statute. There are a few things that seem probably to our ears almost silly now, like beauty pageants and awards for beauty contests are allowed to still be separated by sex. Mother-son dances and father-daughter dances are in there. But then there are some big ones like if the entire institution is single sex, then you can continue admissions based on that sex. And another big one is if an institution provides actual housing based on sex, then that housing can continue to be single sex. If you think about it conceptually, what that is saying is that in those instances, sex discrimination is legal. You are discriminating. You are making the difference point based on sex, but we are going to declare that that is legal. That's not nefarious. That's not, bad discrimination. That's not going to be illegal discrimination. And that's important when we come back to talking about how the education department is twisting up the Supreme Court's Bostock case. So the education department is basically honoring those statutory exceptions that include the residential living being single sex spaces. We'll come back to sports in a moment. Bathrooms and locker rooms were not ever spelled out in the original statute. Bathrooms and locker rooms were spelled out as exceptions that can be single sex in the education department's original 1970s regulations. So now the education department is basically saying to us, well, those were only ever regulations. Those weren't locker rooms and bathrooms weren't something that Congress carved out in the Title IX statute. Therefore, we're not going to honor those exceptions anymore. We're going to call it all we're going to put that under gender identity discrimination now. So those can't be based on sex anymore. Sports is somewhere in the middle, and the education department with this new rule is trying hard not to have us all focus on what this kind of rule does to sports. So back just a few months after they first proposed this Title IX rule, they also proposed a separate rule dealing only with athletics under Title IX. That separate rule is still in the proposal phase. It's still making its way through the administrative process. So what the education department is saying now with this Title IX rule right now is, well, we're not really going to say that this has any impact on sports, because you got to wait and see what happens specifically to rules for sports when we come out with our athletic specific regulation. It's disingenuous, I think, at best, because there is, when you look at the regulations, the long-standing regulations that have dealt with sports, the primary one, the first one, is and always has been a mandate to provide equal opportunity in athletics based on sex. Then it goes on to say that in certain circumstances, you can go ahead and separate based on sex for athletics. In other words, it's never been a Title IX mandate to have sex separated sports. It's been interpreted as permissive. So now you come in with a Title IX rule that has a big general mandate that says gender identity discrimination is prohibited by Title IX, and failure to allow any student to participate in education programs or activities inconsistently with their gender identity is this kind of illegal discrimination now. That's a very broad prohibition now. So to think that it doesn't impact sports is I don't think very credible on the department's part. They really just wanted to punt this issue, I think, in an election year. They didn't want to draw attention to sports before the November election. I think schools that are in states that now have protect women's sports laws going on might find a little cover to keep separating sports, being able to point to the department pretending that this new rule isn't the one that, forecloses sex separated sports. But more likely, schools and sporting associations that govern school sports are going to understand the thrust behind this new rule and are going to continue moving things more and more and more towards self-ID in sports, which of course is just mixed sex sports.
So I had a question about the housing.
Yeah.
They're going to still allow for sex segregated housing, but does that depend on if the college wants to do it or not?
Yes, all of those things are still permissive. This is one thing I think a lot of us miss when we look at Title IX. I think we've taken for granted that the motive behind it was to give women these single sex opportunities in order to give us the space to have equal dignity, equal opportunity, etc. The truth of the matter is, legally, all of these exceptions have only ever been permissive. That's a real problem now. It wasn't a problem for 50 years because nobody cared. I mean, nobody was challenging that women have their own separate things. But the truth of the matter is that, 50 plus years ago, when Title IX came into being, what was important for women at that time was legal protection in terms of being treated strictly equal to men. That was what was important. We were still being excluded on the basis of sex from things where sex shouldn't matter.
Yeah, to at least be able to have the same opportunities, right? They were trying to level up the opportunities there.
Exactly. But nobody ever bothered to spell out and make the case and ensconce into law that women actually are entitled. We have the right to get to have these single sex spaces provided to us. That it's been allowed, but it has never been mandated. And that's where we're at now. Now I think we have to do that work. I think that is part of this generation's wave of women's rights campaigning. That was not needed in the second wave, and now it's needed.
Yeah, I think I had just was talking about that on Twitter the other day. That it's like that's the thing. That's our goal this time. Our goal is that we have to have sex segregated. We have to have our sex recognized in law and spelled
That's
out
right.
and protected, because
Yep.
obviously, like you said, 50 years ago, no one would have even conceived of this.
Yep. Our rights to single sex spaces have only been tolerated and allowed to exist as long as men weren't paying attention and saying, "Hey, I want that."
Yeah.
As soon as men, said, "Hey, I want that," look what's happening. They get it.
I just wanted to ask a question too about then how this implementation treats sexual orientation, because I did notice while reading through that they acknowledged that there were some complaints, and I know our organization did complain about this, about some of the language, and they acknowledged scrubbing some of the ambiguous language like Q plus.
Right.
But I don't think in practice that means much. So maybe just shed some light on how it treats orientation.
Yeah. It just uses the phrase, Title IX now includes, in sex discrimination, sexual orientation, and gender identity. There's no definition to sexual orientation, just like there's no definition to sex or gender identity. In the explanatory pages that the department released, they maintain that there's no need to define any of those terms because they actually say, because they're used everywhere. So everybody knows. It's just So they say they don't have to define any of their terms. With sexual orientation, it's hard to put together. It's hard for me to think that there is a lot to be gained without net loss in saying that, hey, we've got great protections now for school discrimination based on sexual orientation. Classically, those things would arise, in scenarios as blatant as, a gay boy, not being even allowed to join a sports team because his teammates were so grossed out or whatever. I mean, it was just blatant. You are excluded from this school activity because we don't like that you're gay. So there has always been an argument for a need to protect against true discrimination based on sexual orientation. There's a legal argument whether Title IX is the right way to do that, or whether you should go back to Congress and talk about sexual orientation, because Title IX deals with sex. But if you're going to include sexual orientation, but you are also putting everything now under a rubric of self-identity, that's what really frightens me about doing this, because sexual orientation is now at risk of being interpreted so subjectively that I truly believe, if pressed, somebody could in a school environment could legit claim that any kind of paraphilia, any kind of sexual fetish it's my sexual orientation. I can't be discriminated against. You can't say I can't do this and I can't go here and there because it's my sexual orientation.
Well, we already see
it's a
that
problem.
Happening.
Yeah,
we
absolutely.
I mean, it happening
with it's pretty gross.
Yeah, I'm not even clear how sexual orientation fits into Title IX, though. Really, like it doesn't. Just do that in there.
This is a good avenue then to talk about the Supreme Court's Bostock case from 2020, because that's the the top of the pyramid that the education department relies on. Everything flows, all their justifications that have any kind of actual basis flow from relying on the Supreme Court's Bostock case. Supreme Court's Bostock case wasn't about Title IX. It was about a similar sex discrimination statute called Title VII from the 1964 Civil Rights Act. And this particular part of the law says that as to employers, you are not allowed to commit sex discrimination. So what the Bostock case said was looking at an employer who wants to fire someone because of his transgender status. We are going, and this is the key. That was declared illegal sex discrimination by the Supreme Court. But here's why. It's almost overly simplistically, technically logical. The court said, in order to judge somebody negatively for their transgender status, they didn't define transgender status, but whatever, you can't help but take into account that person's sex. Okay, actually, technically that is true. That's the only way you can even conceptualize what transgender status might mean, is if it somehow is being compared to or lined up against the person's sex. So that's how the Supreme Court ended up saying, well, if you can't discriminate based on sex, then you also can't discriminate based on transgender status, because transgender status requires taking into account somebody's sex. Here's the key point, though. That is all in a context of saying we're looking at a situation, termination, firing of an employee, where sex is irrelevant. Sex doesn't matter. Therefore, transgender status doesn't matter either. Now, it doesn't work in reverse. If you are looking at a situation like sex-separated sports or bathrooms, the whole point is, like we were saying earlier, those are situations where sex does matter. Sex is the relevant characteristic. And actually, technically, what you're doing is saying in this scenario, sex discrimination is legal. In those scenarios, the Bostock decision was completely silent. It only said where sex is irrelevant, then you can't discriminate based on transgender status. If sex doesn't matter, transgender status doesn't matter. It does not go the other way around. It doesn't say where sex does matter, oh, actually it's gender identity that matters more. It doesn't say that. So that's the misapplication and unfounded expansion of the Bostock case that lower courts have been doing for a few years now, and that has allowed the education department to say, see, gender identity discrimination applies everywhere, not only where everyone is treated equally despite sex, but also in situations where everybody is divided by sex.
But in the Bostock thing, wasn't it more the fact that this guy was cross-dressing?
Well, that's why the employer wanted to fire him, and the court sort of dodged that issue. The court could have been a little more clear and a little more specific about saying, here's the takeaway for sex specific dress codes, for example. I mean, the court might have, taken some kind of position on it and said, well, there's not a good enough reason to even have sex specific dress codes. So you're going to have to put up, employers, you're going to have to put up with people wearing what they want to wear. I'm just saying the court might have said something like that. Instead, they just sort of avoided it and just focused on the fact that the employer wanted to get rid of this guy because they didn't like his transgender status.
Okay. So then would it be reasonable to predict at some point in the future that the Supreme Court is going to take up this issue again to give further clarification? Because I can't believe that the court with the current conservative majority would be happy with all the different ways that Bostock has been used.
I do think so. I think sooner rather than later, the Supreme Court is going to have to take this up again and clarify it. I don't think they're going to reverse themselves on Bostock. I think they're just going to flesh it out. And I hope it is along the lines of how I read Bostock, which is saying, hey, okay, fine. If sex doesn't matter, sexual orientation and gender identity don't matter either. Fine. And honestly, we can deal with dress codes. I don't have a huge passion about which way the dress code issue ends up going. It's obviously the areas where sex is what matters. That the court has got to clarify that if sex is allowed to matter, then you can't say gender identity also matters, because the two are incompatible. As soon as you say gender identity matters in the same space that sex matters, gender identity overtakes sex, erases it, and becomes the only salient feature.
Bingo. I'm glad you went in and explained Bostock and how that, because yeah, that doesn't make sense. Why would those even?
Yeah,
I haven't thought of it that way, of the sex was irrelevant in that situation, but it's
That's
relevant in this other one.
Yep.
Yeah.
And that, frankly, that the Title IX rule could be bearable. It could be workable if the notion of what is discrimination was properly conceptualized and applied here. If all you're saying is what was somebody's subjective gender identity is not a reason to exclude them from school and school activities, okay, that could actually be workable. Because at that point, it's almost like somebody's religion and religious beliefs aren't gonna keep them from participating in activities either. What they're doing, though, is saying that discrimination isn't just about treating someone the same as anyone else. They're saying discrimination is about giving in to what the individual wants. You have to treat the individual the way they want to be treated, as though their identity claim is somehow the truth or fact-based. It's not just about saying don't be punitive against somebody because they have a gender identity claim. It's saying give in or validate the person's subjective gender identity claim. Those are two very different things.
I could think of this whole thing going differently if trans rights advocates were actually wanting to participate in, the democratic process.
Right.
If a person was trans identified and, cross-dressing and trying to look at the opposite sex, and they were, say it was a guy who went to school and he wanted to play sports with the men and he wanted to go in, they have to allow him. They have to allow this man who wants to do wants to, present himself in that way, do that. Right. And the same with women.
Yep.
I think that would be more of a fair and productive thing to do.
Absolutely. That'd be fine. That would be very workable. It would. But
it's not about that. It's about validation.
No, of course not. It is about the validation. It is about compelling the rest of society to affirm and validate the identity claim. That's just never been done before in U.S. law and most Western post-Enlightenment legal systems. It's never been, well, it has, but we've gotten ourselves in and out of situations where it is basically faith-based or religious views that have grabbed the reins of state power and said, we're going to make laws and official systems that are based on enforcing these religious dictates, these religious tenets. We've done that. But we've also shaken it off and ended up deciding, no, we don't want to do that.
Right. Yeah.
Yeah, I was also really worried too about this idea of sort of retroactively redefining words because they haven't been defined before. Like when Title IX was written, I think people knew what a woman was. And so they didn't bother like having to spell out what it is. And now when there's all these people trying to redefine what that means, now they're using that modern ambiguity and retroactively applying that to the past. And I actually want to introduce another news story that happened that's related to that. It's the Wyoming, involves a sorority in Wyoming, and I'm just going to briefly describe it. On May 14th, the 10th Circuit Court of Appeals in Denver heard Westenbroek versus Kappa Kappa Gamma Fraternity. Kappa Kappa Gamma Fraternity is an Ohio-based sorority whose University of Wyoming chapter earlier voted to admit Artemis Langford, a trans-identified male, as a sorority member. In response, 6 members of the society are suing the Kappa Kappa Gamma National Sorority and its council president, Mary Pat Rooney. They argue that the sorority's bylaws only allow the admission of women, which at the time of the bylaw's creation would not have included trans-identified males. By voting to allow trans-identified males into the sorority, the plaintiff's attorney, May Mailman, argues, the council has in effect amended their bylaws. Hence, the president of the council had violated her fiduciary obligations. However, according to Natalie McLaughlin, the defense attorney for the sorority, it is a right, according to Ohio law, for the sorority council to interpret their bylaws as they please. And the only time a court can intervene is if the council's interpretation is both unreasonable and arbitrary. McLaughlin went on to argue that interpreting women to include trans women is perfectly reasonable and non-arbitrary. She points out that woman is unquestionably undefined in the bylaws, and that it is unquestionably has multiple definitions. So just like the council has a right to interpret regard for others and appreciation for the worth of all individuals in many different ways, McLaughlin argues that the council also has a right to interpret the word woman in multiple different ways. So that's sort of the schmeal of what that case was about.
Yeah. We are paying the price right now for never having bothered to define sex terms because it was unnecessary. The obviousness of the condition of humanity being a sexually dimorphic species was actually, taken as a fundamental fact of the world. You don't have to start from scratch every time you mention a fact of the world. Now that postmodern gibberish has used language games to throw that into question, and I think very kind of bored people have jumped on board and thought, well, this is interesting. Let's see how much we can stir things up by pretending we don't know how anything could be factual anymore. Yeah, we're paying the price for that now. It's never we didn't have to nail down these meanings in law before. Now we do. And I think in a case like the sorority situation, at the very least, I think that the girls in the sorority should take a stance by not even pretending to be a sorority anymore until and unless they prevail on this legally in court and they have the right again to be female only. I don't think they should go along with pretending. I don't think any of us should go along with pretending that this is even still a sorority. It's not. Some kind of club, some kind of social club, but it's not a sorority.
Yeah, and there was another news thing we were following in North Carolina, I think it was, about the WPATH.
Oh, yeah. Okay, so yeah, so there is a case currently going on in North Carolina. It's the case is titled Vo versus Mansfield, and it is funded primarily, Lambda Legal and with PFLAG sued the state of North Carolina in October 2023 because the state of North Carolina banned transition for minors. Okay, so they're suing the state to get basically this 9-year-old girl to be transitioned. So during this case, some documents were released, emails, a chain of emails between lawyers at WPATH and doctors who were working at John Hopkins. WPATH had hired these doctors at John Hopkins to do a basically systematic review of the available material to see if there was proof that gender affirming care was helpful and, basically scientific proof to prove that gender affirming care works. And they came back and said, there's very little evidence out there that this actually works for minors. And WPATH basically said, and this was right before they were trying to do their SOC 8. So their new rules. And they basically kept putting them off, and decided actually not to have that study that they actually asked Johns Hopkins to do put in the new standards of care. And then went and tried to, well, I guess they were successful, make sure that the study that these folks at Johns Hopkins did, they suppressed it and wouldn't let it be published.
Yep.
So this, I mean, to me, this is pretty damning. You can't, this is crazy. I mean, not only is it showing that there's actually no evidence for this, but now they know there's no evidence and they're trying to hide the fact that there's no evidence.
No.
So what's your thought on that, Candice?
I think that it might be the official beginning of the end. I think up till now, in legal cases where validate gender identity laws or provide gender affirming care mandates have won, it is in large part because experts have trotted into court and they're activists or they are captured doctors or whatever, but they have this scientific aura around them and they are taken at face value because they're the experts. But in reality, their own opinion comes back to WPATH, their own assessment of why this has factual and evidence-based value to it and is necessary comes back to WPATH. And so when the foundation for WPATH's own standards of care and own recommendations and own guidelines becomes this shaky, I think it has a real chance of toppling the whole house of cards that the legal victories over the last several years have been built on.
Yeah, because I was thinking, as medical goes, the medical community has never had to follow these. These are their standards of care that they recommend. But WPATH has never, first of all, never been a scientifically based organization, but they've never had the teeth to implement any kind of regulation. There's no board for doctors. There's none of that, right?
Yeah. Yeah.
So it's always been kind of a Wild West situation, but it has played a real relevant, like you said, relevancy in law. Right? Because this is like, oh no, this is scientifically based. Oh, this is life-saving care, so.
Absolutely.
Because the one way I think of it, the whole thing about gender identity, it's so cryptic and so esoteric.
Yep.
You can't realistically argue to a mass population, to normal people who aren't immersed in this worldview, that makes any sense.
Yeah. Especially what they try to connect, right? Saying, going from the weird concept of gender identity to, therefore it means we need this, these kinds of hormones and surgeries. Therefore it means that, single sex spaces, have to disappear. It's that connection that it's so extraordinary.
Yeah, I mean, the medical thing makes the whole gender identity thing seem real.
Right.
Like it's the Trojan horse, maybe you could say, for making actual scientifically valid thing, is if you can convince people that there is some medical reason that underlies the gender identity. And so if that falls apart, if that argument about the medicalization falls apart, then really the whole gender identity thing doesn't have a whole lot to stand on. I mean, in practice, it's clear that a lot of these gender ideology proponents don't really even necessarily care about the medical thing, because the big point about being able to redefine transgender away from transsexual was like this whole idea that like you don't really have to have gender dysphoria, you don't really have to medically transition. But like I said, for the wider population, it's much easier to understand something when there is a medical issue.
I think the wider population really, they sold it well to the wider population by posing this idea that someone has the brain of one sex and the body of the other. Born in the wrong body, I think really got people. And I think the more they move away from that idea, they're going to lose because, you know, people are good. People are like, what? Wait, you know, and they really sold gender dysphoria too as this like horrible thing that has to be medically, because the medical cost is so high for these procedures that you have to up the ante. And that's why they always claim suicide or transition.
That's right.
But there's no evidence for this, actually.
No, you get, now we have the cast review that has you know, legitimately described in agonizing detail the how and why that suicidality and GAC, gender affirming care, being the cure for it is it's all a myth. It truly is a myth.
Oh, so
and once that's gone.
Yeah. I wanted to ask you about that. Will the cast review have an impact in United States courts?
Yeah, I think it will. It's not directly. It's not going to be as simple as, you know, being able to cite to the cast review and saying, therefore, I don't know, you know, we have to accept you know, the cast review's statements or conclusions as somehow legally binding. But I do think it's going to have a huge impact on, again, chipping away, just like with the WPATH files and the revelations, you know, from, you know, that are turning up through discovery about WPATH's internal workings. Those things are going to work together to finally start shaking the wall of supposed consensus, medical consensus. Everybody everywhere says this is the only way to go. Affirmation only. It's life-saving. All of this is going to get chipped away at because finally the proponents of it, who have been marching into court for the ACLU, et cetera, should at the very least now have to answer these questions. Yeah. How can you say this in the face of that? And if they respond in court under oath, supposedly testifying as experts, the way that we've seen groups like the Endocrine Society and the AAPS respond to the CAS report, I hope that judges are finally going to look at that and say, oh, so you have predetermined your conclusion because it's political, it's civil rights, it's, you know, human rights, but it's not medical. You've just predetermined that this is the right thing to do, and so that's why you're advocating it. You have no interest even in backing that up and making sure it's backed up with actual evidence. You don't.
So do you think this is something that could be relevant for the medical malpractice lawsuits?
Yeah, I do.
Okay.
Yeah. In some ways it'll be hindsight, you know, so, but I think what things like the WPATH files and the CAS review does is, CAS review in particular was itself retrospective, right? It took a qualified team and it took a retrospective look over all the supposed studies and evidence that had already been done. So you have every right in a malpractice type situation to ask the particular healthcare providers how and why they relied on these studies, or just grab the conclusions of these studies without asking themselves questions, without, you know, verifying. It starts to unravel a bit in that sense. Yeah. And a lot of these providers in malpractice situations have been very confident about just going in and saying, I follow WPATH. So you can't get me in trouble. I follow WPATH.
This may be slightly off topic, but can WPATH be sued?
I think that I'm starting to think that WPATH, APA, Endocrine Society, AMA even, I'm starting to think that there might be legitimate avenues for direct lawsuits against them. That the questions are going to be finding legitimate plaintiffs. Our legal system doesn't let just any of us who are observing these things march into court really and say, hey, you did something wrong, I'm going to hold you accountable.
Well, because
that's supposed to be done by a person who is directly personally harmed by it. So you got it. Yeah, I mean, I think outright fraud just amounts to somebody reasonably had a right to rely on on statements that were false or misleading, and they did rely to their detriment, and they suffered an injury over it. So outright fraud by some of these,
especially because if it's starting to come out that WPATH knows that this isn't good care, but it's continuing to push it, like where's that's a fault there. They're lying basically, you know.
And
then lying to all the doctors.
Right. And maybe even more relevant to US lawsuits, you know, would be to go after AAP and similar. And the way that they're doubling down in the face of information about WPATH and the CAS review tells me that, you know, 1, 2, 3 years from now, the people who are still reasonably relying on them and looking to them as experts, and they've now had all this information and did not backtrack at all, didn't even question themselves, just went full steam ahead, just starts to make a case for fraud and abuse look even more clear.
That's interesting. Thank you for that.
Yeah, I'm just
real quick, just to circle this back to Title IX, it is fascinating to me that the Department of Education, other than citing to the Bostock case and lower court decisions that have interpreted Bostock in this wrong way, the only other thing that they rely on is pointing to WPATH. They've got a little footnote that says their whole rationale for declaring that failure to treat somebody in accordance with their gender identity is super important to mental health and, you know, practically life-saving, comes back to WPATH. Their footnote cites to SOC 8, WPATH, and AAP, their 2018 policy, and I think one like non-rigorous Psychology Today article or something like that. But that's it. They have like 3 citations for this huge premise that we have to upend society and quit letting women have separate spaces because it is vital to the mental health of somebody with a gender identity. That's it.
Yeah.
So it really comes back to in full circle there to hopefully be a big part of these 8 or 9 lawsuits so far challenging the Title IX rule. I think they're going to have some good grounds to show that the whole rule is based on something that is provably false and shaky enough that the whole rule is seen as arbitrary.
Okay. Yeah, it really does all go back to WPATH, it seems. And so that's why I asked about it.
Well, thank you for all that information. Is there anything else you want to share before we wrap up?
No, this has been such a great conversation. I would encourage people to keep an eye on the challenges to Title IX, because I think there's a good possibility that one or more of those is going to be one of the first signs that some of this is starting to break wide open.
All right, thank you for that. And thank you for joining us. You, as always,
absolutely
full of great information. I learned something new today.
Same. Well, thank you.
Yes, thanks a lot, Candice. And with that, we are wrapping up this week's news roundup. So thank you everyone for joining us. Good night, good morning, wherever you are, whenever this is. See you next time.